Hello friends, I am B.N. Agarwal, ex-Chief General Manager, Steel Authority of India Limited, Bhilai Steel Plant, Bhilai. I am again back on the same issue, that is EPS 95. The total stand is still on the issues right from the decision of the Honorable Supreme Court almost 26 months back, that is November 2022. आज मैं आप लोगों के लिए सिर्फ ट्रस्ट रूल, जो एग्जेम्प्टेड ट्रस्ट रूल का इशू है, उसके बारे में बात करना चाहूँगा और कोशिश होगी कि एक फैक्चुअल, लीगल एंड कॉन्स्टिट्यूशनल ओवरव्यू आप लोगों को दे पाऊँ। आज मेरे ऑनलाइन जो असिस्टेंट है, माय लैपटॉप will be helping me. I'll be reading a lot from my laptop also, because some of the issues are required to be known to my friends. Now, what are the issues? Because I'll be questioning and I'll be answering in this session. Issues are generally that internal trust rule limits contribution to pension fund to rupees 6,500 per month. Another issue is that there are no provisions in the trust rules for pension on higher wages. And many of the EPFO regional offices, cases of exempted trust have been remitted to their higher authorities, that is EPFO headquarters, for certain clarifications and directions on the trust rules, which are pending almost more than a year, I understand. Now, before going into the issues of trust rules, I thought it appropriate, almost the whole day I was working on this, as to we should see what is exemption and what is non-exemption, what are the exempted trust and what are the unexempted trust. Many of you might be aware that there are around 1,300 exempted trusts prevalent in the country as per the data available in EPFO site. This exemption is given to the trust to run their own PF matters inside the organization, so that employees need not, run after this office to that office for their day-to-day withdrawals, for their final withdrawals and anything and everything relating to PF matters. There is a specific section 17(1)(a) of EPF Act 1952, wherein there is a power to the central government to exempt the establishments, mainly who are having more than 500 workers, having more than 50 crores worth of corpus of the employees, on the analogy that the rate of contribution and other benefits will not be less favorable than those specified in the act or schemes. बिल्कुल ठीक है ये बात कि कोई भी पीएफ ट्रस्ट अगर चलाना चाहता है तो जो गवर्नमेंट की स्कीम है उससे कम का बेनिफिट उसमें एम्प्लॉइज के लिए या एक्स एम्प्लॉइज के लिए नहीं होना चाहिए. Now a very important point is that this exemption is for running the provident fund, not for running or maintaining the pension fund. Today I could see that exemption from pension scheme and pension fund, there is a separate section 17(1)(c) in the EPF and Miscellaneous Provision Act 1952. Thereby, if an organization wants to have an exemption altogether from government scheme to have its own pension scheme, it can do so. We are not governed by that. I think most of the exempted trusts are not necessarily, but yes, I believe most of the exempted trusts are not having their own exempted pension schemes and pension fund. Now you know stringent conditions are available in EPF Act and EPF scheme 1952, para 27 AA, most important, of the EPF scheme 1952, an appendix of 31 conditions known as Appendix A is there, according to which internal trust rules are to be made. I'll talk about internal trust rule in detail, but some of the conditions are necessary to know. Condition 10, the most important for us, says that any amendment to the scheme which is more beneficial to the employees than the existing rules of the establishment shall be made applicable to them automatically and pending formal amendment of the rules of the trust. ये बहुत इम्पॉर्टेंट है, इसके बारे में हम डिटेल में आगे चलकर बात करेंगे. Condition 11 says that no amendment in the rules shall be made by the employer without the prior approval of the RPFC. मेरी मर्जी नहीं होगा एम्प्लॉयर का, approval is required from RPFC. Condition 16 says that employer shall file such returns monthly, quarterly, annually as prescribed by EPFO within the specified time. Condition 22 says the employer and board of trustees at the time of grant of exemption shall furnish a written undertaking to the RPFC agreeing to abide by the conditions which are specified or to be specified. बहुत ही 3-4 जरूरी कंडीशन को मैं यहाँ पर अभी जिक्र किया. Now, some time back I was going through an exemption manual circulated by EPFO on 9th of November 2023 and shared it to me by one of my friend. Page number 24 of the exemption manual says that establishment has to constitute a trust and formulate the trust rule based on the condition of the exemption. ये मैं ढूंढ रहा था कि ट्रस्ट रूल बनाने की जरूरत कहाँ पर है, आज मुझे मिला ये एग्जेम्पशन मैनुअल में. नाउ पेज 30 ऑफ द एग्जेम्पशन मैनुअल, दैट इज चैप्टर 3, ये भी बहुत इंपॉर्टेंट है. दो द एग्जेम्पशन मैनुअल रन्स इनटू ऑलमोस्ट 250 to 300 पेजेस आई बिलीव. Chapter 3 says regulation and management of the exempted establishments. This chapter aims to lay down the essential guidelines necessary for the management of the exempted establishments and the regulations thereof by EPFO based on statutory provisions indicated in the Act and the schemes. The scheme of the exempted establishment functions within the ambit of the Act. As such, the framework for its proper functioning is similar to EPF scheme under the Act. Very important कि हम जो भी ट्रस्ट रूल बनाते हैं, it has to act within the framework of the EPF Act and EPF scheme, employee pension scheme. Now then, what is the internal trust rule? Internal trust rule is only for provident fund contribution, trust management, trustees management, withdrawal, investment and day-to-day management of the trust. It's a kind of, a bylaws. It is not for pension scheme, that is pension entitlements, pension calculation, pension payment, pension management, opening of the pension fund account, investment of the pension fund, valuation of the pension fund. These all are entirely done by EPFO and its offices. Now one more thing I would like to say, that contribution to PF, Provident Fund, in most of the cases always on actual higher wages. that is basic plus DA plus retaining allowance. That is more than ceiling wages. And in internal trust rule, as it always happens in any bylaws, there are certain safeguard provisions also which says that if there is any inconsistency between the internal rules and the EPF Act and EPF scheme, then always the EPF Act and scheme will prevail for all purposes. Now coming to EPF 1995, which is the subject matter of discussion also. I think I said earlier also in my previous video that there is no EPS Act as such. A specific section 6A of EPF Act 1952 provides for EPS and known as EPS 1995 with effect from 16/11/1995, which supersedes completely family pension scheme FPS. A particular section 6A2D specifies that the member of EPS shall pay such sum as central government may specify. Very important. Looks to me it is very important. We cannot decide the ceiling wages on our own. An establishment or an employer or a trust cannot decide. So, rupees 5,000 initially, then 6,500 from June 2001 and 15,000 from 1st September 2014 has been specified by the central government, and this has not been decided by the exempted trust. I was looking back the trust rule for the establishment where from I come. I found there was no provision in the year 1995 for remittance of EPS contribution in the trust rule to EPFO regional office. But then contribution to pension fund at the rate of 8.33% of the employer's contribution subject to a ceiling wages of 5,000 rupees per month with effect from 16/11/1995 was complied with in respect of all the members. Why and how? I said condition 10 of para 27 AA of EPF scheme 1952, which says that if there is any beneficial scheme, no need to wait for formal approval or amendment in the trust rules. So 1995, nothing there in Provident Fund rules, internal rules. Then 6,500 came 1/6/2001 onwards. Notification number 383 dated 21/05/2001. Again same thing. ट्रस्ट रूल में कोई अमेंडमेंट नहीं हुआ 6,500 रुपीज के लिए 2001 में. अगेन बाय वर्च्यू ऑफ कंडीशन 10 ऑफ पैरा 27 AA कैपिटल AA we started remitting to the extent of 6,500 rupees per month का जो भी बनता है 8.33 that is 541 rupees per month we started remitting. As far as Bhilai Steel Plant is concerned, trust rule got amended in September 2007 to include ceiling wages of rupees 6,500 per month. बट जैसा मैंने आपको बताया अभी कि कंट्रीब्यूशन पेंशन फंड में 2001 जून 2001 से अगस्त 2007 तक इवन विदाउट अमेंडमेंट इन द ट्रस्ट रूल एम्प्लॉय के खाते में पेंशन फंड में जो ईपीएफओ मेंटेन करता है उसमें रेमिट होता रहा. वन मोर फनी थिंग, सीलिंग वेजेस 15,000 रुपये हो गया 1/9/2014 onwards. Wide notification number 609 dated 27/20 22nd August 2014. This continued, and this continued almost till now. Only 2-3 months back some amendment has been made. For almost 10 years, even without amendment in the trust rule. Again, by virtue of condition 10 of para 27AA, appendix A ka. One more interesting thing is that many people have retired in between. Prior to the judgment of Supreme Court, all the pension payment orders, PPO, were based on these ceiling wages of rupees 5,000, rupees 6,500 and rupees 15,000. Though the same were not suitably included in the trust rules. Almost नहीं था ट्रस्ट रूल में. तब फिर क्या हुआ? बहुत सारी सेफगार्ड प्रोविजंस हैं. पैरा 16A of EPS 1995, it guarantees pensionary benefits to the pensioners. That if there is any non-compliance on the part of employer, the pensioner should not suffer. Even the employer is not remitting the contribution from employer's contribution to the pension fund, that is 8.33% of 5,000 rupees and 6,500 rupees and 15,000 rupees, then also pension cannot be stopped. These are the safeguard provision. Social security and financial stability, that is the mission. Section 13(1) of EPF Act. What is that? Inspection by EPFO. Very stringent conditions are there. Timely inspections are required to ensure that trusts are running the way it is required to run, for everything, for remittance, for employee benefit, for payment, for audit and what not. 31 conditions are there. I cannot discuss at this moment. So everything was going well. And even in the rule book, EPS 95, there were provisions for higher pension, there were certain cut-off dates, and those all were the subject matter of dispute before the court, and a judgment, I should say a landmark judgment, came in the year 2016, precisely 4th October 2016 in Sri R.C. Gupta's case. The Honorable Supreme Court, wide para 7, I said I will take help of my laptop, otherwise I will not be able to speak. Para 7 says that a beneficial scheme, as per Honorable Court, a beneficial scheme in our considered view ought not to be allowed to be defeated by reference to a cut-off date, particularly in a situation where, as in the present case, the employer had deposited 12% of the actual salary and not 12% of the ceiling limit of rupees 5,000 or rupees 6,500 per month. ये बहुत ध्यान देने योग्य बातें हैं. एक्चुअल सैलरी का 12% हम लोग देते आए हैं प्रोविडेंट फंड में. नेक्स्ट पैरा 10 में, इस कंक्लूडिंग पैरा, इट इज सेड बाय द ordered by the Honorable Court that at best what the Provident Fund Commissioner could do and which we permit him to do under the present order is to seek a return of all such amounts that the employees concerned may have taken or withdrawn from their Provident Fund account before granting them the benefit of the proviso to class 11(3) of the pension scheme. Once such a return is made in whichever cases such a return is due, consequential benefits in terms of this order will be granted to the said employees. मतलब आपने जो पैसा निकाल लिया हमारे जैसे पेंशनर लोग, आप उस पैसे को वापस कर दीजिए. लेट कमिश्नर सीक रिटर्न ऑफ द सम, which is the present case also. Then what happened? 2016 का डिसीजन के बाद में ऐसा क्या हुआ जो नहीं हो पाया अभी तक? It is now almost 8 or 9 years. A circular has been issued by the EPFO dated 23rd March 2017. I will go through one para out of that circular which is most important. The Ministry of Labour and Employment white letter dated 16th March 2017 has conveyed its approval to allow member of the Employees Pension Scheme 1995 who had contributed on higher wages exceeding the statutory wage ceiling of rupees 6,500 in the Provident Fund. Remember, in the Provident Fund, to divert 8.33% of the salary exceeding rupees 6,500 to the pension fund with up-to-date interest as declared under EPF scheme 1952 from time to time to get the benefit of the pension on higher salary on receipt of joint option of the employer and employee. वही कहानी है जो अभी है. 2016 में भी यही बात थी. मिनिस्ट्री ने अप्रूवल भी दे दिया, सब कुछ सही था. फिर क्या हुआ? 2 महीने बाद 31st May 2017 EPFO came up with another circular. You know, it was a bulldozer. Para 1, beginning para of that circular. Approval to comply with the order of Honorable Supreme Court in the matter of Sri R.C. Gupta and others is only in respect of the Provident Fund and pension members whose accounts are maintained by EPFO and whose PF contribution on higher wages has been received by EPFO, means unexempted trust. क्योंकि unexempted trust का पूरा पैसा EPFO पे डायरेक्टली जाता है. Para 5, for me it is very important. In the case of exempted establishment, the Provident Fund and pension funds are managed by separate legal entities. Mind well, they are themselves telling in their circular that both are maintained by separate legal entities. Again, the Provident Fund of the employees of the exempted establishments are managed by exempted trust. Provident Fund exempted trust manage करते हैं. And pension fund is managed by EPFO. यही तो हम बोल रहे हैं कि हम पेंशन फंड मैनेज नहीं करते हैं, हमें मत लपेटिए इसमें. Now comes present decision of EPFO versus Sunil Kumar. Latest judgment 4/11/2022, 26 महीने अभी से. Salient features. Para 37, 38, 44, 2 of the order. For everybody who is from exempted trust, this 3 para most important for us. There are 5 lines in these paras. I will read out. I have taken out from those paras. Number 1, the employees of the exempted trust shall also be entitled to the pension beyond ceiling wages and can exercise option for this with the EPFO. Number 2, the employees of the unexempted establishment and exempted establishment form a homogeneous group. एक जैसे हैं, एक ही ग्रुप है. Employees of an exempted establishment should not be deprived of the benefit of getting option to remain in the pension scheme while drawing salary beyond the ceiling limit. ये एलिजिबिलिटी है हमारी 6,500 रुपए या 15,000 रुपए जो बोल रहे हैं उसके ऊपर में. If the employees of the exempted establishments are excluded from the pension scheme, it would lead to artificial classification of otherwise same categories of employees. आर्टिफिशियल क्लासिफिकेशन हो जाएगा. इन्होंने तो आर्टिफिशियल सब क्लासिफिकेशन भी कर दिया है, मैं बताता हूं अभी. The pension scheme ought to apply to the employees of the exempted establishment in the same manner as this scheme applies to the employees of unexempted or regular establishment. जैसा उनके लिए वैसे ही हमारे लिए है भाई. क्या exempted establishment को अगर हम अभी सरेंडर कर दें कोई ऑर्गेनाइजेशन अगर सरेंडर कर दे तो वो एलिजिबल हो जाएगा, और एग्जेम्प्टेड है तो नहीं होगा बिकॉज ऑफ ट्रस्ट रूल। देखिए मैंने लिखा है, नथिंग हैज बीन मेंशन्ड and are ordered by the Honorable Supreme Court regarding enforceability or applicability or requirement of amendment of the internal trust rule for eligibility to the pension on higher wages। ये फैक्ट है। 434 पैराज में सुप्रीम कोर्ट ने डिटेल में डिस्कशन किया एग्जेम्प्टेड ट्रस्ट को। नोवेयर इट इज डिस्कस्ड एंड टोल्ड दैट there is a need for amendment, there is a need for enforceability of the internal trust rule. Nothing has been discussed and no need to discuss in my opinion। पैरा 43 of the order, ये तो बहुत इंपॉर्टेंट है और बहुत इंटरेस्टिंग है। We are of the view that time limit for coverage beyond the ceiling amount should be extended by a further period of 4 months from today to enable all the members of the pension fund drawing more than rupees 6,500, I am repeating, drawing more than rupees 6,500 to exercise the joint option as contemplated in para 11.4 of the pension scheme। Means what? Supreme Court is also admitting the fact, taking cognizance of the fact that if you are contributing to your provident fund on a wages more than 6,500 rupees, then you are eligible for higher pension। Somebody said your trust rule has not been amended। Sir, think that internal trust rule cannot be amended in anticipation of any such direction by the apex court prior to the decision and or direction of the apex court। I have written this para for a purpose। I read somewhere that it is the contention of the EPFO that amendment to the trust rule for higher pension should not be an afterthought। Sir, how it will be an afterthought? It is the decision of the Supreme Court which is required to be implemented। You know, series of circulars have been issued by EPFO post Supreme Court decision for compliance। लुक्स टू मी करीब 15 सर्कुलर्स और इंस्ट्रक्शंस इशू हुए हैं। सेंट्रल गवर्नमेंट एंड मिनिस्ट्री ऑफ लेबर एंड एम्प्लॉयमेंट आल्सो अप्रूव्ड इम्प्लीमेंटेशन इन दिसंबर 2022। उसके बाद ही इनका सर्कुलर इशू होना जारी हुआ। फनी थिंग इज दैट नो सर्कुलर स्पीक्स ऑफ इंटरनल ट्रस्ट रूल्स और अमेंडमेंट देयर ऑफ, कि अमेंडमेंट की जरूरत है, कि इंटरनल ट्रस्ट रूल को देखने की जरूरत है, ये कहीं किसी सर्कुलर में नहीं है। It is only in their, perhaps in their internal note it is going on. It is a paper submitted to, employers, that is establishment, it is going on। 15th November 2024, just 2 months from today, EPFO pension manual for the first time, almost after a period of 30 years, 1995 में EPS आया। It has been issued. It does not contain any stipulation about the applicability or enforceability of internal trust rule on any matter relating to pension on higher wages। Then what is the ceiling wages in internal trust rule? It is purely and simply verbatim adoption and reproduction of ceiling wages as in EPS scheme and notifications issued by government in this regard। Obviously, trust or establishment or the employer cannot decide any ceiling wages। And as I said, that Supreme Court decision granting pension on higher wages benefits is applicable with full force in view of the condition 10 of para 27AA of the EPS scheme, even without any amendment in the internal trust rules। Going forward, as I said that I will be discussing factually, legally and constitutionally also, Article 141 and 144 of the Constitution of India mandates that law declared by the Honorable Supreme Court of India is binding on all the courts and authorities in India, and all the authorities in India must act in aid of the Supreme Court decision. EPFO's denial of higher pension despite the clear Supreme Court ruling is in violation of this constitutional obligation. Obviously, Supreme Court ruling is applicable on EPFO also. EPFO authorities are also to act in aid of Supreme Court decision. I can read out some paras out of Supreme Court decisions, but I will not because of time constraint. One more thing, supremacy of statutory provisions over subordinate rules. ऐसा तो आता है माइंड में कि क्या इंटरनल ट्रस्ट रूल सुप्रीम हो गया ओवर द सुप्रीम कोर्ट. Obviously, internal trust rule cannot override the parent act, that is EPF Act, which is passed and approved by the Parliament. Notifications and circulars issued by the government would always prevail upon any circular, upon any internal rules or bylaws of the trust. And above all, decision of the Supreme Court would always prevail upon act, circulars and internal trust rules as well. आज ही मैं पढ़ रहा था, in Constitution there are three lists: central list, state list and concurrent list. It is written in the Constitution itself. If there is any conflict between the central list and state list, the central list will prevail because that is approved by the Parliament. So here also the act will prevail, Supreme Court will prevail on everything. Doctrine of promissory estoppel and legitimate expectation बहुत इंपॉर्टेंट है. सुप्रीम कोर्ट के डिसीजन के बाद में इन्होंने सर्कुलर इशू किया, ऑनलाइन सिस्टम दिया, कंप्लीट वेरिफिकेशन किया, डिमांड नोट दिया, डिपॉजिट लिया, एंड आफ्टर दैट either they are not returning back the deposit or they are keeping everything stand still is against the decision of the Supreme Court, against the doctrine of promissory estoppel and legitimate expectations. एक बहुत इंपॉर्टेंट और भी पॉइंट आ रहा है, वो ये है, identically placed exempted trust having similar trust rules are being treated differently by the EPFO authorities, which is nothing but violative of Article 14 of the Constitution, that is equality before the law. Pension on higher wages is being considered in many of the regional offices in the state of Rajasthan, West Bengal, Jharkhand, Odisha, Haryana, Uttarakhand, Madhya Pradesh, Karnataka and New Delhi. I will not give the name of the exempted establishments at this moment, but demand letters and in some cases revised pension orders are available with us. Here I will say this is, artificial subclassification between the exempted establishment. मतलब कहीं किसी exempted establishment को मिल रहा है और कहीं दूसरे exempted establishment को नहीं मिल रहा है, having similar kind of trust rules. तो ये तो artificial subclassification हो गया. Now we all know there are total chaos in last 26 months since the decisions of the Apex Court in November 2022. Retirees, senior citizens at the age of 58 to almost 68, last 10 years हो गया ना, 68, they are settling from pillar to post. to get higher pension, and in some cases even to get back their deposited amount running into millions. You have mission social security and financial stability, सामाजिक सुरक्षा और वित्तीय स्थिरता. कहीं ये असुरक्षा में या अस्थिरता में तो नहीं बदलने जा रही है. हमें जो विश्वास है हमारे एक बहुत बड़े विभाग के लिए, देश के और नीति निर्माताओं के ऊपर में उसे दूर ना होने दिया जाए. इन्हीं भावनाओं के साथ धन्यवाद. नमस्कार.
Don't forget to like, subscribe and share the videos.